Deborah, I have another tough case that you don't know anything about.
So I should sit back down.
Mr. Weller's sleeping through most of this, but we're going to wake him up here to do our hearing.
I wondered.
And it's got a lot of money involved, and he's not real with it, and he's late. And I'd ask if you would stay. I apologize.
Anything to make this
It's another no lunch Monday. Why don't you go ahead and turn it back on for you now? I would have considered even maybe bumping this, but the complainant is here and he's been waiting for a long time. This is file 23738FY, People versus Timothy John Weller. Mr. Weller was charged with a felony computer crime. And as I mentioned, we're returning to the bad old days of multiple remands. This matter was bound over to the circuit court on a felony charge. A large amount of money was taken, $8,000, and it got remanded back to our court for a plea and sentencing. Well, I'm not sure I'm ready to do a plea and sentence, but I would be ready to do a plea. They're remanding these matters back for plea and sentence, but by the nature of the fact that they were a felony and came back as a misdemeanor, they're complicated. I don't know what happened. This case got bound over. There were several status conferences. It was going to be set for trial, and it got remanded. And so the remand plea, Mr. Weller, would be to a misdemeanor charge of larceny over $200, but less than $1,000. The original charge was an allegation that you stole $8,000 from a Mr. Gregory White.
Buckle up, guys. Today we're going to dive headfirst into Judge Middleton's courtroom. He wastes no time laying out the $8,000 theft remand history from felony to misdemeanor. You'll catch the crucial file numbers and sense the stakes skyrocket instantly. Notice Middleton's brisk, no-nonsense style as he demands clarity from both sides. The tension simmers under every exchange, signaling this plea won't be routine. His refusal to delay underscores his respect for victims trapped in legal limbo. By the end of this opener, you're hooked for the showdown to come next. This sets the tone for an intense judicial showdown.
That larceny charge is a just plain old grand larceny, punishable by up to 5 years imprisonment and a fine of up to $10,000. The computer part of it is a allegation that used a computer program, computer system, or computer network to steal more than 1,000 but less than 20,000. That's punishable by up to 7 years imprisonment and a fine of up to $5,000. You're also charged as a habitual felon as a fourth felony offense, making this punishable by up to life in prison. So the matter got bound over to circuit court. The can got kicked down the road a little ways, and then it got remanded back here for a plea to a misdemeanor charge of larceny more than $200, but less than $1,000. Mr. Weller, that's a misdemeanor. It's punishable by up to a year in jail and a fine of up to $1,000 or 3 times the amount of the money taken. In this case, it's alleged to be $8,000. So the prosecutor, and let me confirm this, Ms. Davis, has offered to dismiss the felonies and the supplemental for a plea to larceny over $200. And I understand you inherited this, but thank you for being here.
Quickly looking through the notes, it appears that yes, Prosecutor Marvin had made that offer larceny 200 to 1,000, and that the restitution was $8,000 joint and several between Weller and Sproul.
She is set for sentencing later this month with Judge Pattison. All right, Mr. Weller, the allegation is that you're going to be ordered to pay $8,000 restitution joint and several with Heather Sproul, one of your co-defendants here. you understand?
Yes, sir.
Could you take your hand away from me? Are you gonna plead to that misdemeanor charge of larceny over 200 but less than 1,000?
Yes, sir.
Mr. Bush, you confirm that's the plea
Yes,
offer?
it'll be more on an aiding and abetting factual basis, but we have previously discussed that. And this is not a spur of the moment decision today.
All right. Mr. Weller, do you understand that if you do plead to that charge, you'll be giving up your right to have a trial in front of a judge or jury?
In this segment, Middleton meticulously dissects each charge on the table. Grand larceny and computer fraud penalties hang in the balance, with years or life at stake. He contrasts maximum sentences against the prosecutor's misdemeanor plea offer. Watch him corner counsel for clarity on fines, restitution, and sentencing. His commanding presence leaves no doubt who runs this courtroom. Every procedural nuance becomes a strategic chess move in his hands. He probes underlying facts to reveal the true weight of this deal. By the close, you realize there's far more at play than a simple plea bargain.
Yes, sir.
If you had a trial, you'd have the right to be represented by an attorney. Mr. Bush is here with you. You can also hire an attorney of your own choosing if you wished. If you had a trial, you'd have a right to have any of the witnesses for or against you subpoenaed to come to court so they could be questioned under oath. You would have the right to take the witness stand yourself and testify on your own behalf, but you don't have to because you have a right not to testify. And if you did not wish to testify, the judge or jury could not hold your silence against you. And you have the right to be presumed innocent if and until the state was able to prove your guilt beyond a reasonable doubt. Do you understand?
Yes, sir.
Did you somehow induce the complainant here, Mr. White, to give you $8,000?
No, sir.
Well, tell me what happened.
I was solicited by Miss Ellis Brown to go open an account in my name, and what she did, she stole Mr. Gregory White's phone and transferred the money from his phone into my account. Somehow she got a hold of my account information and transferred the money into my account.
All right, that was $8,000. All right, well, and then you took $4,000 of that dollars and blew it at the casino?
No, you did not. The only thing I got out of that was like $500. Your Honor.
Well, you must have known there was some nefarious purpose for you to just blankly open an account.
She told me that, Your Honor, not to cut you off, but she told me that she inherited the money from her uncle. So I went and opened the account, and she went and, like I said, stole Mr. White's phone and transferred it. That's how she got his information. That's
All
from
right,
that
but
phone.
then you withdrew $8,000 from the Omni
That's
Bank.
because I believed her that she inherited that money, Your Honor. If I had known that, like I told Mr. Gregory White, if I had known it was his money, I would never have done it in the first place.
Timothy stated Heather gave you $3,600 and she kept the rest.
No, that's not true.
Now that's what the police say.
He must have misunderstood what I was trying to tell him.
All right, well, you didn't just,
And
yes.
Mr. We've talked about this, and in retrospect, you realized that it was kind of a hinky thing that
Yeah.
that money was there for just a couple hours and you were paid either their theory, multiple thousands or $500.
I still can't take responsibility for it, Your Honor. What?
All right, so you knew this wasn't all on the up and up.
The focus shifts to the plea colloquy as Middleton lays out Weller's rights in vivid detail. Jury trial options, counsel choices, and subpoena powers whirl in his advisements. Weller's uneasy explanation of the $8,000 transfer meets relentless questioning. Middleton's scrutiny exposes every inconsistency in the defendant's story. Defense counsel scrambles to steady their client under the judge's glare. The balance of legal formality and raw human drama makes this riveting. You can almost feel the courtroom lights tighten as truth inches closer. This exchange sets the stage for accountability in the next act.
Right, Your Honor.
And he's open to his share of restitution. I suggest to the court that he wasn't as sophisticated as the other individual to put this together.
He's also not as dumb as he presents here. He knows more than,
I'm willing to pay him back whatever the court wants me to pay him back.
her name is Sproul. Let me see, because she's set for sentencing on a certain date. Let's see if we can line these up, save the complainant. Well, that can't be right. Set for sentencing on September 5th. So let's see how I look for September 5th at 10:30. It's next Tuesday. I can do it. All right, I'll accept your plea at 10:30. I'm not sure how we're going to do this. Let's say it. Mr. Wilson?
Yes, Your Honor, please the court, I provided transportation for Mr. White because quite frankly, he has none. And I will not be able to do so during the month of September.
Well, I can, the other case is already set for September 5th. Mr. White, I can give you a bus pass to get here and back on September 5th. So I'll give you a round trip bus passes for that morning. But you're gonna need to be here for Ms. Sproul anyway. So here's 2 round trip bus passes for you to get here on September 5th. Courtesy of generous people that watch this channel.
What time are
I'm gonna set this for 11. The other one's at 10:30. Now, you called this morning, you were out of state or you had to be somewhere. How'd you get here today?
Cousin, my cousin brought me all the way back.
All right, how'd you get here to the courthouse?
My cousin drove up here.
Where's he?
Judge Middleton's skepticism takes center stage as he picks apart Weller's narration. He teases out withdrawal fees, timeline gaps, and potential misrepresentations. Remaining mindful of the victim's plight, he frames restitution as adjustable. Sentencing logistics and scheduling slip in seamlessly alongside tough inquiries. This is classic courtroom choreography. Tough love for truth with a nod to fairness. The tension between process and justice threads every probing question. No detail is too small to escape Middleton's relentless gaze. By the end, you understand that every nuance matters in real justice.
He took off. Yeah, I'm supposed to let him know how I'm supposed to get a hold of him because he has no phone now.
Hi, could you guys check and see if Mr. Weller drove here today? Yes, thanks. Bye. You've got a terrible driving record.
Yeah, they'll see me getting, Your Honor, I have to cut you off again, but they'll see me getting out of a passenger seat of a maroon or burgundy colored Dodge
All right.
and passenger side.
Now, in the
It was in this parking
report,
lot out
you're
here.
talking about driving. The other thing I need to confirm, I don't know whether that interview was recorded. According to the affidavit of probable cause, she gave you $3,600, which you took to firekeepers and lost, except for $23. Plus, you were driving all over the place.
I learned my lesson from
I
that,
made
Your
a
Honor.
traffic stop bearing a Michigan temporary plate, made contact with Timothy Weller in the driver's seat. I don't know what I'd do to keep you from driving. So there's a dispute about how much money you took. You don't have 2 nickels to rub together. I'm not very encouraged about this man getting his $8,000 back. But you agree that the restitution will be $8,000 joint and several with Miss Sproul?
Like I said, I'm willing to make this right with him. I mean, I feel bad about it, and I'm willing to do whatever it takes to make it right.
I have not looked at this carefully, obviously, so in just going over the bank statement that I pulled up, there may be some withdrawal fees and that sort of thing, so
Okay.
I guess I would like to leave that restitution somewhat open. I mean, it's expected it's going to be around the $8,000, but there may be some fees. I want to get that cleared up so that the victim is made right. But I also have concerns about Mr. Weller's ability to be here himself on Tuesday. And if we have the victim coming back and the other co-defendant, I want to make sure that he is going to be here as well. So I guess I'll leave that to the court's discretion as far as that goes.
I'm willing to come back.
All right, yes, your bond's canceled.
Well, that's one way to ensure that he comes back. Cancel.
In a surprising twist, Middleton arranges free bus passes for the victim's return. It's a rare blend of empathy and pragmatism rarely seen in legal arenas. Then, with decisive authority, he cancels Weller's bond to ensure compliance. This procedural pivot underscores how process can serve both people and principle. Middleton's actions show that access to justice must transcend barriers. Every move crackles with the weight of real-world consequences. This segment reminds you justice isn't just rulings, it's deliberate, humane action. You leave convinced action speaks louder than courtroom rhetoric here.
We'll deal with it. That's next Tuesday, which is 8 days. Stealing $8,000 from this guy certainly develops at least 8 days. Plus you keep driving a damn car.
No, I think he's been in jail for upwards of 45 days in this case.
Yeah, he bonded out. I'm not sure how. And I set the bond at the amount that was stolen. I think it got reduced when it was remanded. And I don't like these remands, and there's not much I can do about it, but they come in, they're always difficult to deal with. Yes, your bond's canceled. You're no longer presumed to be not guilty. I will see you next Tuesday at 11 o'clock.
One more custody.
Thank you, Your Honor.
What am I going to deal for?
Your bond's canceled.
Guilty to helping somebody steal $8,000 from this man.
Yeah.
Plus you showed up late and slept through most of the earlier proceedings. I'm not sure what's going on with you, but I hope you're in a better state of mind when I see you next Tuesday morning. All right, you're free to go.
Thank you, Your Honor.
Why am I being arrested for? I don't understand. I've almost got my pleas in.
Oh, it's too late for that. We can discuss
Why am
that
I being
next
arrested for, man? I ain't
You're
doing anything wrong,
not
man.
arrested. You pled guilty to stealing $8,000
No, I pled guilty.
and then canceled your bond.
Man, it's crazy, man.
Yes, I think so.
Okay.
One of us is. All right, I'll see you.
Middleton delivers final admonishments as he revokes Weller's bond outright. He sets the next hearing date with surgical precision, underscoring seriousness. His closing remarks leave no doubt about accountability and personal reform. Every procedural decision echoes a clear message: courtroom decorum matters. In under 3 minutes, he turns legal jargon into a moral directive. Observing this finale, you witness how authority and empathy coexist. It's a powerful reminder that every courthouse moment carries human stakes. If you enjoyed this breakdown, please hit like and subscribe to the channel, and we'll see you in the next video.